What kind of person tells the ward manager that a colleague is mentally unfit to return from maternity leave, and then applies for that colleague's job the same afternoon? I want you to hold that question, because the answer is more specific and more documented than you might expect, and I want to tell you about what happened when we filed the counter lawsuit, about what the employment tribunal judge said when she read the evidence bundle, about the specific face a person makes when they understand, in real time, that the thing they thought they had buried has just been placed on a table in front of a judge. I'm going to tell you all of it, but first I need you to understand what the 7 months before that courtroom cost us, because the numbers are the kind that change a person permanently, even after they are recovered. My name is Lauren. I am 31 years old. I am a senior staff nurse on a cardiology ward in a hospital in Newcastle. I'd been in that role for 6 years when I went on maternity leave in January, having worked through the final 8 weeks of my pregnancy in the specific exhausted determination of someone who has not told anyone how tired she is, because the ward is always short-staffed and the patients keep arriving. My son's name is Theo. He was born on the 22nd of January at 4:17 in the morning, weighing 7 pounds and 1 ounce, and for approximately 4 hours I held him and thought about nothing except how warm he was, and how completely the world had reorganised itself around this one small fact. By the afternoon of the 24th, the ward manager had received a written communication expressing concerns about my fitness to return. The person who sent it was a colleague named Pamela. She had been on the same ward for 4 years. She was my grade, my age, within 2 years, and had, for the entirety of our professional overlap, been positioned in the ward's informal hierarchy, in the allocation of complex cases, in the manager's calculation of who was developing fastest, just behind me, not dramatically, quietly, in the specific way that proximity to something you want can make the gap feel larger than it is to the person standing in it. I want to give Pamela her dimension, because she is not simply a function of malice. She had worked extremely hard. She was a good nurse in the technical sense that matters most to patients. She had applied for a senior clinical lead position the previous year and had not been appointed. I had been. That appointment had created something in her that she had not resolved, and by the time I went on maternity leave, she had had 12 months to build a story in which the gap between us was unfair rather than earned. I understand that story. I do not accept it, but I understand how it gets constructed in the quiet of ambition that is not satisfied over 12 months of watching someone else hold the role you wanted. The written communication she sent to the ward manager said that she had observed, in the weeks before my leave, what she described as concerning signs of emotional instability and difficulty managing complex caseloads. She said she had been reluctant to raise it earlier, but felt, given the imminent return to work discussions, that she had a professional duty of candour. Professional duty of candour. My partner is called Ben. He is a secondary school teacher and the most methodical person I have ever met, in the specific way that people who manage 32 teenagers a day become methodical out of sheer necessity. He was the one who found out about Pamela's communication, from a friend on the ward who told him in confidence. Not knowing what to do with the information, Ben sat with it for one evening, during which I was feeding Theo and he was very quiet, and then on the following morning he did 3 things. He contacted ACAS, he told me, and he made a list. The list was what Pamela had sent to me by email and internal message over the previous 8 months. Not the communications about clinical matters, as the other ones, the invitations to drinks she had extended and then cancelled last minute, the messages asking whether I had seen particular job postings internally, framed as casual but arriving on dates I later cross-reference against specific vacancy announcements. A message in October that said, "You must be thinking about your options with a baby coming. I imagine you'll want to slow down a bit." A message in December that said, "I applied for the Band 7 development programme. I think they're looking for people who can commit long term," which I only mention because of your timing. Your timing, my maternity leave, which is a protected characteristic under the Equality Act 2010, Section 18, and which cannot lawfully be used as a factor in any employment decision or communication regarding an employee's professional future. Now, I want to stop and reframe everything I just told you because I have been describing a nursing colleague making pointed remarks and sending a letter to a ward manager, and that might sound like workplace unpleasantness that most people absorb and survive. So let me tell you what it looked like by February. By February, I'd been called into a meeting with the ward manager and HR to discuss concerns about my return to work. The meeting was framed as supportive. The ward manager was visibly uncomfortable. The HR representative was reading from a form, and I was sitting across a table from two people, 14 days after giving birth, being asked whether I felt I was in a position to manage a full caseload. I had £412 in our joint account. My statutory maternity pay had not yet processed for the month. Ben's salary covered the mortgage and the food and the utilities and approximately nothing else. Theo was asleep in a carrier on Ben's chest in the waiting room outside, because we could not afford childcare for a single afternoon yet, and because the idea of leaving him with anyone while I sat in that room felt physically impossible. £412. I told Ben everything that evening. He listened until I finished, and then he said, "We are going to need a solicitor." He said it in the tone he uses when he has already decided something and is informing me rather than proposing it. I found this, at that particular moment, to be the most supportive thing anyone has ever done for me. We found a solicitor named Grace through a legal advice service recommended by ACRES. Grace was 43 years old, spoke in complete paragraphs, and had a specific quality of controlled impatience with employment law violations that I found immediately reassuring. She read the emails, she read the timeline, she asked 2 questions and wrote something down. Then she said, "The communication to the ward manager constitutes maternity discrimination under Section 18 and potentially harassment under Section 26 of the Equality Act." She said, "The emails are evidence of a sustained pattern." She said, "We are going to file." We filed at the Employment Tribunal in March. The claim covered maternity discrimination, harassment related to a protected characteristic, and detriment in connection with pregnancy and maternity leave. Grace quantified the claim at £47,600, loss of potential career progression, injury to feelings at the upper vento band given the timing and the sustained nature of the conduct, and costs. She also included a formal complaint to the Nursing and Midwifery Council regarding Pamela's professional conduct communication on the grounds that it constituted a false statement made in a professional context. Pamela's solicitor responded in April. The response was aggressive. It denied every element of the claim. It characterised Pamela's communication to the ward manager as a good faith clinical concern, raised in accordance with professional duty. It described the emails as misconstrued and taken out of context. It included a counter-statement from Pamela characterising our relationship as one of mutual support disrupted by Lauren's own increasing workplace stress in the months before her leave. And then, in the final section, Pamela's solicitor filed a counterclaim against me in the county court for defamation on the grounds that my tribunal claim, and specifically the NMC complaint, had caused reputational damage to Pamela's professional standing. The counterclaim sought £15,000. I read the counterclaim at the kitchen table at 11 in the evening while Theo slept. Ben put a mug of tea in front of me, the kind of instinctive small act that a person does when they have nothing adequate to say but need to do something. The mug was warm. I held it with both hands and sat with the specific sensation of a situation getting worse in a way you had not prepared for, which is not quite fear, but is adjacent to it. Ben said, "This is a mistake she has made." He was right. Grace told us the following morning that the counterclaim was almost certainly an abuse of process, that a tribunal claimant's statements made in the course of legal proceedings are protected by qualified privilege, and that a county court defamation claim, based on those statements, had a very low prospect of success. She filed a strikeout application immediately. The county court struck it out in 6 weeks. Costs awarded against Pamela, £3,800, personal liability. Now, here is the delayed reveal. The thing I have been building toward, the thing that neither Grace nor I had anticipated, and which arrived 11 days before the tribunal hearing in a supplementary bundle that Pamela's solicitor had been required to disclose following a specific disclosure order. The ward manager kept notes. Handwritten contemporaneous notes dated and signed, made at the time of Pamela's original communication. The notes recorded not only what Pamela had said, but something she had added at the end of the conversation, something she had said when the ward manager had asked what specifically had prompted her concern about my fitness to return. The note read, Pamela stated that with Lauren on extended leave, there was an opportunity for the ward to reassess its senior clinical structure. She referenced her own interest in the clinical lead development pathway. An opportunity, she had said it herself, to the ward manager, who had written it down. Grace presented the notes on the second morning of the employment tribunal hearing. The panel read them in sequence. The employment judge, a woman named Susan, looked at Pamela's solicitor and asked whether his client wished to revise any element of her evidence in light of the contemporaneous record. The solicitor asked for a short adjournment. Susan gave him 30 minutes. The adjournment lasted 2 hours and 14 minutes. When Pamela's solicitor returned, he informed the tribunal that his client was prepared to settle. The settlement was £63,000. Full payment, a written acknowledgement, not legally an admission, but drafted by Grace in language close enough to admission to be unambiguous, that the communication to the ward manager had been inappropriate and professionally unfounded, a formal retraction to the ward manager of the fitness to return concerns, and a withdrawal of any claim to the clinical lead development pathway for a period of 2 years. £63,000 arrived in our account in September. Ben stood in the kitchen looking at his phone for a long moment. Then he said, "Right, just that, right." And then he made tea, because that is what Ben does when a thing that has been enormous becomes smaller, and a mug of tea is a thing that fits the moment. The mug. The same kitchen table where I had held it with both hands 11 months earlier, reading the counterclaim in the dark. The same warmth held the same way in the same hands, different weight entirely. I am back on the ward. The ward manager greeted me on my first morning back with a specific combination of warmth and relief, of someone who has been uncomfortable about something for a long time, and is grateful it has resolved. I said nothing that needed to be said. Theo started nursery in October. He is, by general agreement, the most good-natured person in any room he occupies. This is Ben's influence, I claim it jointly. Pamela is no longer on the ward. I do not know where she is. The NMC review of her professional conduct to communication is ongoing. That process has its own timeline, and I am not its narrator. But here is what I have not resolved and what I want to leave you with. The ward manager's notes. She had written down the opportunity comment at the time. She had kept those notes, and she had not, in the months between Pamela's communication and the tribunal, brought them forward herself. I have thought about why. Perhaps she did not know they were relevant. Perhaps she did not know the claim existed. Perhaps she made a calculation about what her role required her to do, and found something that felt like neutrality in not volunteering what she had written. She disclosed them when legally required, not before. I am not angry about that, but I think about it. What would you have done in her position? If you had written that note and you knew what was happening and nobody had yet asked you directly, would you have come forward? Tell me. Because I genuinely believe the answer is more complicated than most people admit, and the complication is worth sitting with.